joining us today. My name is Ian Scott, and I am the founder of Scott Legal. And today we are going to talk about moving from a non-immigrant visa to a green card and the different ways to do that. So before we get started, a few housekeeping items, a few things about this webinar. We will record the webinar and we will send it to you, the recording to you after, and some other things that we will send you. A copy of the PowerPoint presentation that is in front of us. We'll also send you guides to the various different types of visas that we talk about today. We will send guides that have a lot more information in them, and we will also send a consultation link if you want to set up a consultation to talk about your facts and circumstances. If you do have questions, feel free to add them to the chat or to the Q&A. We will get to all questions. The last thing that I wanted to talk about is that we will go through each of these topics at a pretty high level, but we do have individual webinars on each of these topics. So for example, when we talk about the national interest waiver, we do regularly have webinars that just deal with the national interest waiver. So they go into a lot more detail than I will go into here. So without further ado, let us get started. So the first thing I wanted to talk about is really just how the green card system works in the United States. And the system works in the United States and the system is very different from the way it works in other countries like Canada and the UK, et cetera. In other countries, a lot of them have a points-based system where people will get points for a number of different things like speaking the language, their education, their age, different things like that. And once they reach a certain number of points, they would be able to get some type of permanent residency or the equivalent of a green card. But the United States doesn't have anything like that. So the time that you spent in the United States doesn't matter. The visas you've had, your language, et cetera, none of that matters. Instead, there's just a list of categories, and each category has criterion, and you have to look at them and see whether you are eligible. And if you are eligible, then you can apply for the green card. And what we do see is that people move from certain types of visas more often than not to other types of green cards that may be closely aligned with them. But before we get into that, the green card categories are broadly broken up into two areas. There are more, but broadly broken up into two areas, one being family-based and the other being employment-based. On the family-based side, we have a category called immediate relative, which is a term defined by immigration. So an example of an immediate relative would be a U.S. citizen marrying someone, so that then wanting to get that person a green card. And that particular category under immediate relative has a lot of advantages in terms of how fast the visa can be processed, the green card can be processed, et cetera. And then there are preference-based categories. So an example of this might be someone that is a U.S. citizen and they have a sibling that they want to sponsor for a green card. And usually those categories have much longer waits, so are not as advantageous as the immediate relative categories. The employment-based categories are broken down into EB1 through EB5, and we'll be talking about each of those except for EB4, which is a religious-based green card, which our firm does not do, and we won't be talking about that today. So I mentioned already a little bit about the family-based, where there's an immediate relative and preference-based categories, and gave a couple of examples. And again, the kind of primary benefit of the immediate relative category is that the visas or the green cards, because visa and green card can be used interchangeably, that they are current all the time. And what current means is that the way that the green card system works for both the employment-based and the family-based is that the government has set out a number of different green cards that can be issued each year. And then once that quota has been met, then people go into a queue, a line. So the example that I used before of the US citizen that wants to sponsor their sibling, that line is quite long. It's around 14 or 15 years before the green card is available. But the benefit of the immediate relative category is that the immediate relative category is always current. So the green card is always available. So it's just going to be faster. So those backlogs can really put a damper on how fast someone can get a visa. And sometimes in some instances, like the US citizen wanting to sponsor a sibling, it almost, for all intents and purposes, makes the category impractical in terms of ability to get the green card. So for all of these green cards, there's a process. It's either two or three-step process. So the first step is going to be an objective step, kind of indicating whether or not the person's eligible for the benefit. So for example, in the family base, If it's a U.S. citizen marrying someone, they're going to be looking at whether or not the marriage was to a bona fide, or whether the marriage was a bona fide marriage. So they're going to make sure that the marriage was legitimate. And in this case, it's going to be an I-130 petition that's filed. And then the second part is either going to be consular processing or adjustment of status. For the persons outside of the United States, they're normally going to do consular processing. And if they're inside the United States, they can do adjustment of status if the category is current. So for immediate relative, that's always going to be current. But under the preference-based categories, if the sibling example that I use, one would not be able to file the I-485 or even do consular processing until the category actually became current. And with adjustment of status, the benefit of that is that the individual can file for work authorization and travel authorization. So you can have a lot of the benefits of the green card before you actually even get it. So we do see a lot of people moving from visas to under the family-based categories. They come maybe on an E2, TN, H1B, et cetera, and they meet someone and then marry a U.S. citizen and marry, or they may have a parent that is a U.S. citizen or green card holder, and they're able to sponsor them. And sometimes the delays work out in terms of the ability to still get the visa benefit. But yeah, definitely it's a category that we do move a lot of people from visas to green card. Now, this first employment-based category is EB1A, and what this category is relates to is someone who's risen to the top of their field. And what the government tries to do to assess whether or not someone has risen to the top of their field is that they have listed 8 particular criteria, and they say that the individual has to meet at least 3 of them. So, for example, they say that if someone is making a really high salary, then that might be an indication that they've risen to the top of their field. Let's say that they are asked to judge the work of others. When you look at American Idol, the judges that are used to judge the work of others, they are people who are already extremely accomplished in their field. It could be awards that you've been winning or you've been published in major trade publications or magazines. But that's what this particular category is going to look at. And often when we look at EB1A as a movement from a non-immigrant visa to a green card, it's usually someone who's in an O1 capacity. And O1 is the non-immigrant visa that is very similar to EB1A, but we'd almost say that EB1A is pretty much O1 squared in terms of if you have an O1, then you would have to be, even more exceptional to be able to get the EB1A because they're going to look at making sure that you actually have met everything that's required to move up to EB1A. So the next one we're going to talk about is EB2, National Interest Waiver. And this is a category, again, the last one is a very high bar. This too is a very high bar. And the reason this is a very high bar is because the government says that they're going to give you a green card if you are coming to the United States to do something that they consider nationally important. So this is the first step in this particular scenario is to determine what it is that you're coming to the United States to do. Like, so what is your endeavor? Like, what are you coming to the United States to do? And once you've done that, you will make the assessment as to whether or not the government feels that that is of national importance. So again, it is a very high bar. It could be that what you're doing is bringing significant economic benefit. It could be that you've invented some new or innovative technology that could be rolled out to others. It's often going to require expert letters that both describe what the national importance is or what the importance is to the government. The other criteria here is that the person has to be well positioned to advance the endeavor. So they really look at track record here. Track record is going to be a key thing. And they're going to look at your experience and really your ability to move the thing along. So they're not really interested in the situations where people just have an idea that may be, a great idea and that may be in the national interest, but they want to make sure that the person is actually going to be able to advance the actual proposed endeavor. And then the government does a balancing test to say, well, we already think that protecting U.S. jobs is in the national interest, so we have to look at other factors to assess whether or not we should still give this person the green card. So that's it is a very high bar. This is a great petition for strategy and utilizing attorneys that kind of understand the nuances and the case law associated with this, because this is one of the few immigration benefits that is based on a case rather than the regulation. And but for the right petition, it really can be a great move to a green card. We see people moving to NIW, they're on H-1Bs, they can be on E-2s. Sometimes we've done E-2s where people have made an economic impact argument based on hiring US workers, in particular in areas that were economically depressed. And that can be something that, the way that people move to an actual green card. With this particular category, there's a threshold issue with respect to applying, and you do have to, and this particular category is under EB2. And for any EB2 benefit, you have to have an advanced degree, which is a master's or higher, or a bachelor's degree plus 5 years experience, or exceptional ability. And there's seven criteria that we look at for exceptional ability. And for all of these, they have to be related to the area of your endeavor. So you couldn't have an advanced degree in philosophy if you were, if your endeavor was to be an entrepreneur. So the two have to line up. Now, with both the EB1A and the EB2 national interest waiver, there is an ability to self-petition. So you don't need an actual employer. So that's a significant benefit of this particular petition type. It is a two-step process where you first file an I-140, and that is going to be the tough part. So that's either going to be proving that you actually do have the exceptional ability, or proving that you have met the NIW, the national interest waiver criteria. Now, the categories are current for the most part for these right now, EB1A and EB2. And if they are current, then you're going to be able to, and you're in the United States, you can file the I-485, and again, with the employment authorization and the travel authorization. And also, if you're outside of the United States, then you're going to be going through consular processing. The next way that people move to a green card is through companies sponsoring them for a green card. So either sponsoring them or sponsoring their spouse for a green card. So let's say someone's on an E2 and then the spouse has work authorization and the spouse gets a job somewhere else. And then the company says, hey, I want to sponsor you for a green card. Then both parties would get that immigration benefit of the green card. Now, EB2 and EB3, the difference between them is the EB2 is for professionals and EB3 is for unskilled workers. Now, again, if you're doing EB2, this is the same category as the NIW. You have to meet the threshold criteria. But under this, where the company is sponsoring you for a green card, the company is going to go through a three-step process. The first is going to be they're going to work with the Department of Labor to make sure that the company cannot find a qualified U.S. worker. That's called a PERM process. And that can take about 18 months to 2 years. And then once that's approved, then we can apply for the I-140, which is the objective part of the analysis. And that has an ability to do premium processing. So that can be an answer in 2 weeks. And then once that's done, we're going to be looking at either the I-485 or consular processing. So this category, we see a lot of people that move to this green card based on being on H-1B, being on TN visa. Sometimes when someone's on E2, their spouse might get a job, but it's really probably one of the most significant ways that people move to a green card. The next one they're going to talk about is EB5, and this is the investor-based visa. And so this is where someone invests either 800,000 or 1,050,000 in either a regional center, which is a kind of let's say that a hotel chain want to raise capital and they participated in the EB5 program, and then the individual could give the hotel chain the $800,000, and then they would use that to invest. Or it could be a direct investment where the person has their own business and they're investing in their own business. And so the difference between the 800,000 and the 1,050,000 really depends on whether or not where the business is located. So if the business is located in a targeted employment area, then it's going to be 800,000. If the business is located in not in one of those areas, then it's going to be 1,050,000. And targeted employment is based on either the unemployment rate is 1.5 times the national average, or the business is located in a rural area. So the amount of the investment does have to come from your personal investment, so it can't be money that's accumulated in retained earnings. And in addition, there's a source of funds analysis that's done. So they really do have to understand where you're getting the money from. So that's quite an extensive analysis, and it is more like an audit than anything else. And this is a equity investment, so it can be a limited partnership unit, it can be stock, or it can be a membership unit, something like that. The other big part of the EB-5 is that you have to create 10 full-time jobs. So that's either the regional center for each green card or direct investment. Um, and both of them are going to need a business plan because they're going to approve the I-526 petition, which is the petition, the objective part saying that you've invested the money and that you have potential to create the US jobs. They'll approve that based on a business plan. And the investment does have to be linked to job creation. With the full-time jobs, they do have to be full-time, so not part-time. And then also they have to be jobs that are people that are U.S. citizens or green card holders. So it is really important to make sure that you use an E-Verify or some similar system to make sure that they are legitimately able to work in the United States. The filing of this petition is either an I-526 or I-526E. If it's E, it's because it's a regional center. Or and then once again we go through the whole thing as long as the category is current, and they're pretty for the most part the categories are current right now. And that you're going to be filing an I-485 or the consular processing, depending on where you are. Then there's a third step in this process where 2 years after you get the green card, you have to file an I-829 petition to show that you've actually created the 10 full-time jobs. Because they'll approve this based on you saying that you're going to create 10 full-time jobs, but then they want proof of it later. The next is some other options for green card. We have the diversity lottery. So every October, they select 50 or 55,000 people and give green cards to them. Some countries are not eligible based on the fact that the country has had a lot of immigration in the past. There's some humanitarian-based green cards helping police with a crime, victims against violence, asylum, things like that. And then, there's always the hope that there'll be some type of immigration reform that offers more options. I think it's when someone's on a non-immigrant visa, when they're on an E2 or an L1 or TN, they always and they're moving to a green card. They always have to kind of look at timing considerations because we always do really have to understand. Kind of where we are with respect to EB-5 and where we are because EB-5 takes a long time, and we have to make sure that the person has underlying immigration status during the whole time of their application. So there is a lot of planning that is required here. And because sometimes these can drag on for quite some time, and you also have to kind of look at if you're in the United States, like sometimes you may have to be landlocked for a while. So you have to look at not only your visa expiration dates, but can you travel or do you have the advanced parole? When will it be approved, et cetera. And then also when we're applying for a green card, some non-immigrant visas are not dual intent, like a TN visa is not. And we do have to kind of look at when the person entered the United States and whether or not they can apply for the immigration benefit, because you can't enter the United States with the intent to adjust status. So it's something that we work very closely with clients. And often clients have parallel green card strategies. Like someone might be applying for EB-5 and then they meet a US citizen, and then that's an easier process. So they decide to do that. So definitely there are lots of options there. And really, I think the key here is that planning is key. So I think that is all in terms of the prepared remarks today. Definitely if you have any questions, anybody has any questions, you can put them in the chat or the Q&A. I don't see any questions right now. I'm just going to go to the Q&A and see if I see anything. I don't see any questions there either. So if that's the case, we can end there. And we definitely, as I said, we're going to send you information. We're going to send you a copy of the presentation. We're going to send you the video, and we're going to send you a link where you can set up a consultation, and we'll also send you the relevant guides so that you can so you'll have all that information handy. And thank you very much for joining. Bye bye.